Our next speaker is Sidney Powell. Ms. Powell is the author of License to Lie, a narrative of the disturbing events, missteps, cover-ups, malfeasance, and corruption of justice that have caused her to question the system she's been committed to for over 30 years. She served in the Department of Justice for 10 years in Texas and Virginia and has devoted her private practice to federal appeals for the past 20 years, first as an assistant United States attorney and later as chief of the appellate section for the Western and Northern Districts of Texas. Ms. Powell is a fellow and past president of the American Academy of Appellate Lawyers and has been lead counsel in more than 500 appeals in the United States Court of Appeals for the Fifth Circuit. To give her perspective on, in particular, federal instances of Brady violations, please welcome Sidney Powell.
Thank you so much. I agree with Dean Epps that there are a substantial number of very good prosecutors across the country. Most of them work very hard and try to do it right. I disagree that most instances of prosecutorial misconduct are accidental. Unfortunately, I think there are a lot of deliberate instances of prosecutorial misconduct. The Supreme Court has been very clear that if there is any doubt in a prosecutor's mind whatsoever, he is to disclose the evidence. That is a clear mandate from the court, but that is not what the current Department of Justice is doing. That's not what the Department of Justice has done for the last 14 years, as best I can tell, crossing both administrations. This is a non-political, bipartisan, nonpartisan issue of fairness and what we expect from our justice system. In the case I talk about in the book, primarily, well, two of them, the Stevens case and the Merrill Lynch case, prosecutors knew exactly what evidence was crucial to the cases, and they deliberately withheld it. Speaking of reports, the Judge Emmett Sullivan in the Stevens case had to appoint a special prosecutor to investigate the Department of Justice itself because it had repeatedly claimed throughout the trial that they had produced everything they were supposed to produce, but time and time again, the defense caught the government public integrity section, no less, of the Department of Justice prosecutors in flat-out lies. So Judge Sullivan, at the end of the proceedings, decided his only remedy to get to the truth of the matter was to appoint a special prosecutor to investigate the Department of Justice and the public integrity section itself. He produced on March 15, 2012, a 500-plus page report that identified systematic, intentional, and pervasive misconduct within the Department of Justice. Those prosecutors still worked there. Two of them who were found to have committed intentional violations still work there. The Project on Government Oversight within the last year did an extensive review of Freedom of Information Act information obtained from the Department of Justice. As far as I know, it's either a nonpartisan or bipartisan group. I really don't know what their extensive background is. But they identified hundreds of instances of intentional or reckless prosecutorial misconduct, and the current Attorney General refuses to release the names of those prosecutors. Prior Attorney Generals have at least released the names. This one has refused to do that. In the Merrill Lynch case that I talk about in the book, the prosecutors actually yellow highlighted before the trial in 2002 statements of witnesses that they knew directly contradicted every aspect of their case. It contradicted what they told the jury 16 times in closing argument alone. It contradicted the testimony of their key witnesses, directly contradicted it, as in, no, there was no guarantee versus the prosecutors saying, yes, there was a guarantee. They proved their case by hearsay-only evidence of people who were not even a party to the conversation that supposedly constituted the crime. In the indictment, they pieced together parts of different statutes to create a crime out of something that wasn't. The Honest Services Statute, when there had been no bribery, no kickbacks, no self-dealing by any of the defendants. And as the judge sent them off to prison, imposing sentences of 3 to 4 years, he acknowledged that they were just doing their jobs. But nonetheless, they had to report to prison. The prosecutors vehemently opposed even bail pending appeal, so we couldn't get them bail pending appeal. They voluntarily reported to prison. They were at least allowed to report themselves, and their families drove them to report to prison, knowing that there was absolutely no precedent for this prosecution. There was no other case from any court in the country that made what they did a criminal offense. The prosecutors who yellow highlighted the evidence that directly contradicted their case became our longest serving Chief White House counsel, the acting Attorney General for the Criminal Division of the Department of Justice, who then micromanaged the prosecution of United States Senator Ted Stevens. We didn't know that until we got the Schulke report, what a strong hand and role he had played in that. And the third one became General Counsel, Deputy Director of the FBI. He has just circled back to Department of Justice to head the corporate fraud section. And the person who primarily responsible for indicting Arthur Anderson, destroying 85,000 jobs, again on an indictment that didn't state a crime at the time, and was reversed by the Supreme Court a couple years later, 9-0, with the court saying it was shocking how little culpability the jury instructions required. They just took criminal intent out of the jury instructions, and a federal district judge in Houston gave that instruction to the jury. That person is now the Assistant Attorney General in charge of our criminal division. So the Enron Task Force cabal, as I call them, within the last 6 or 7 years have populated at least 6 very high positions in the Department of Justice. Under the prior administration, they all received the Attorney General's Award for Excellence. And we filed grievances against Chief White House Counsel, General Counsel, Deputy Director of the FBI, and the Acting Attorney General for the Criminal Division with the respective bar associations. The Texas Bar sent it back by return mail saying we didn't state a grievable offense. This is despite the fact that the Fifth Circuit held that they plainly suppressed evidence favorable to the defense, which is the ethical standard incorporated in Rule 3.8 of the ethical rules. And we filed I think it was a 35-page complaint done by one of the country's leading legal ethics experts, Bill Hodes, who wrote The Law of Lawyering, Hazard and Hodes. He drafted and filed the complaints against the lawyers, the prosecutors. So Texas sent that one back by return mail saying we didn't state a grievable offense. Oh, I forgot to mention there were 500 pages of exhibits, including the yellow highlighting versus, their quotes in the transcript of what they told the jury versus the contrary yellow highlighted information that they could only have deliberately excerpted from the supposedly accurate summaries they were court-ordered to give us. The one against Catherine Rumler, Chief White House Counsel, just kind of seemed to turn to dust and blow away in the D.C. bar. And the one filed against Andrew Weissman, Deputy Director of the FBI, he was actually represented by the Department of Justice in opposing the grievance because he was head of the FBI at the time. The New York Bar kind of let it sit for about 18 months, and then without us knowing it, they punted it to the Office of Professional Responsibility within the Department of Justice to decide the grievance. So the Department of Justice is defending him on the grievance, and the Department of Justice is deciding the grievance. And as you might just kind of coincidentally imagine, they saw nothing to grieve against Mr. Weissman, and that disappeared in time for him to become a fellow at NYU, a senior fellow at NYU. A few weeks later, very quietly left the FBI with no media attention whatsoever, and then time went by, and just recently he was named head of corporate fraud at DOJ. So I wish I could tell you that there weren't seriously calculated corruption of justice by prosecutors, but I can't, and I think we've got to go to open files by law. We need the Fairness and Disclosure of Evidence Act passed, or something like it, that provides open file discovery, that codifies the Brady rule. At the same time the Stevens report came out, there was a coordinated national effort to introduce the Fairness and Disclosure of Evidence Act. It was supported by a bipartisan group of 6 senators. It was supported by everyone from the ACLU to the National Association of Criminal Defense Lawyers. The only opposition it received was by federal prosecutors in our now ironically named Department of Justice, and it died in committee. I find that absolutely inexcusable and intolerable. If someone is going to walk in a courtroom and say, "My name is Sidney Powell, I represent the United States of America, and I'm going to threaten your life, your liberty, or your property," I better get it right and do it right. That is all any U.S. attorney I worked for, and I worked for 9 under both administrations and both political parties for 10 years in 3 different districts. That's all I ever heard. But we're talking about many, many years ago, and I'm not going to say how many, but a long time ago, certainly not within the last 14 years. So we have got to get back to that. And we must have something that holds individual prosecutors as accountable as they want to hold you or I for their deliberate and intentional misconduct, be it perjury, be it subornation of perjury, be it obstruction of justice, because that's really what a Brady violation is. You can whitewash it and call it a Brady violation, but it is obstruction of justice, and it often amounts to subornation of perjury. Prosecutors are never prosecuted. They are very rarely disbarred, and we just have to do better by everyone than that until they are held accountable. And Judge Kaczynski just recently, in his decision in the oral argument of the Baca case, which you can find in one of my articles on the New York Observer at observer.com, you can hear the oral argument. He suggested perjury prosecutions for prosecutors. I think if we did that a few times, or if we made a rule that says if you intentionally convict someone by withholding evidence you knew exonerated them, like the bloody bandana in Michael's case, you serve the sentence that that person got. I think that would jolly well put a stop to it. And as Judge Kaczynski has said, judges can do a lot to put a stop to it. Another thing I've done is draft a Brady compliance order that every state court judge and every federal judge could enter in a criminal case tomorrow to require rolling production of Brady with sanctions immediately put in effect by the judge if there's a violation. It could be as simple as barring that lawyer from that judge's courtroom, or referring them to the bar with a strong admonition that they be disbarred. There are all kinds of options available. But it's time to do something, and there is a significant bipartisan coalition building to work on it. Write your congressman, demand passage of the legislation, write letters to the editor, and remember on an individual basis the presumption of innocence. They can make up crimes, they can make up facts, they can make up what they call evidence, and there are innocent people sitting in our prisons right now.